Good day. My name is Al Poskanzer. I'm a senior investigator with Foresight Science and Technology Incorporated. By way of background, I was formerly the Director of Technology Transfer at Arizona State University and also the Director of Technology Licensing for the Boeing Company. I've got 25 or 30 years of experience in licensing and negotiating intellectual property deals. Today's webinar is entitled Licensing and Negotiating the Deal. If you have an invention or some sort of new technology and somebody else wants to use it, the name of the game is you have to negotiate an agreement with them that allows them to use your technology. And the purpose of today's webinar is to talk about the different types of agreements that you can do, and also how you might negotiate those agreements, because that's critically important. On the next slide, I'm going to go through, starting with this slide, I'm going to go through a number of different types of agreements that can be done, all of which involve transferring the rights to your technology. It all starts with once you find a partner or a licensee, and then before you can actually start the use or the deployment of your technology, you need to get a deal done. And there are various types of deals, and there's actually a continuum of different types of deals. The one thing they all have in common is that there's almost always some sort of a transfer of rights to negotiate that particular agreement. So to start off with, and I'll go through some of these fairly quickly, there's what we call a strategic partnership. Similar to a license in that intellectual property rights are conveyed, which, as I've just mentioned, it does set forth a negotiating division of intellectual property ownership and intellectual property rights. To clarify that comment, if you have a technology and you license that technology to another company, they may take the technology and make improvements on it. Once they make an improvement, if the people within that company have made an improvement, that company may very well own the improvements, but not the background technology, but the improvements. A strategic partnership establishes the responsibilities and the rights of both parties. It sets forth some due diligence and achievement of milestones, which are critical. Usually these types of agreements involve very early stage technology, which must be more fully developed in order for it to be commercialized. Usually an investment by a larger partner will impact the royalties and the licensing revenue of the smaller partner where the intellectual property originated. In other words, if you're a small company and you want to license your technology to a larger company, chances are the larger company is going to make a significant investment in the further development of that technology. And because of that investment, they're going to argue that they might not pay the same kind of a royalty as a straight licensee might pay, because by their investment, they're actually buying down the cost of the technology. An example of a strategic partnership would be a small biotech startup partnering with a large pharmaceutical company. The biotech startup has developed, for instance, a new anti-cancer therapeutic. They own the patents. The recipient of SBIR awards, currently perhaps in phase 2. They've conducted one phase 1 clinical trial. They've had excellent results. And they need additional investment capital in order to advance the therapeutic through phase 2 clinical trials and beyond. The big pharma company, on the other hand, has a drug delivery technology useful for this therapeutic. They own the patents on the drug delivery technology, and they have a worldwide distribution system, which the small biotech startup does not have. A big pharma company has the capital to complete clinical development through phase 3, obtain an NDA from the FDA, and they want an exclusive royalty-bearing license to big pharma, or the small company wants to do an exclusive royalty-bearing license to the big pharma for the life of the patents for the cancer field of use. There will be upfront license payments to the startup, the license payments to be used by the startup for further discovery research. There will be new discoveries optioned to the big pharma. In other words, the small biotech startup is continuing to do further research, and the big pharma would be very interested in that. And there'll be due diligence obligations by the big pharma for the clinical development and commercialization of the technology. That's an example of a strategic partnership where both companies are in it together to commercialize a technology. Another type of collaboration or a deal would be a research collaboration. There are various types of intellectual property involved in a research collaboration. There's a background intellectual property, which is owned by a party before an agreement. There's what we call foreground intellectual property, which is developed by one or more parties under an agreement. Ownership of intellectual property is very often an issue. The right to practice the intellectual property is an issue. And research collaborations typically will set forth a negotiated division of intellectual property ownership and intellectual property rights. Again, you're both in it together. You're both doing research together or on the same technology at the same time, and you need to collaborate together on who's going to own this intellectual property and how the intellectual property is going to get commercialized and so on. The research collaborations often establish the responsibilities and rights of both parties. An example of this is you're working for a university. You might be a professor working for a university. You're dealing with a major aerospace corporation. That aerospace corporation has offered to give you a grant of $500,000 a year for 5 years to advance the technology that you're developing. They want you to do research to develop new robotics technology, for instance, and you happen to be an expert in this area. The foreground intellectual property is owned by the recipient under the agreement, the recipient being the major aerospace corporation. I'm sorry, the recipient being the recipient of the money. And there's usually a non-exclusive royalty-free license to the sponsor. Again, the sponsor being the major aerospace corporation. It's limited to aerospace applications with a right to sub-license to suppliers. Under that agreement, there's often a time-limited first right to negotiate an exclusive license. In other words, the sponsor gets a non-exclusive royalty-free license, but they also have a time-limited first right of refusal to negotiate an exclusive license. The recipient of the research funding can license the technology to others outside of aerospace for royalties, but it has to be outside of aerospace. There is no additional business relationship associated with a license like this, or an example like this. Now, a straight license, which is often some of the most common types of intellectual property agreements, simply conveys the rights to use your intellectual property. There are various types of licenses. There are exclusive licenses. There are non-exclusive licenses. There's also a little bit less common, but there are also co-exclusive licenses where you simply declare how many exclusive licensees there will be. And under many of these licenses, there's what we call a field of use limitation. In other words, you can grant an exclusive license to use for a specific use to one party, while you grant another exclusive license to use that technology for a different use to another party, and so on. So you can have multiple exclusive licenses, providing that the uses specified in each license do not overlap with each other. An example of an exclusive license Very often you'll see exclusive licenses in healthcare technologies. For an example, you might have a topical drug delivery vehicle, something that you put an active ingredient into that can be put into an ointment, for instance. That license will carry worldwide exclusive rights to the drug delivery vehicle technology. The license would be for the patents only. There would be no know-how in this. The term of the license would be the life of the last to expire patent. Sometimes there may only be one patent. Sometimes there may be multiple patents on the same technology. The field of use is limited to pain management therapies in this particular example. Under a license like this, there will often be an upfront fee. We call it the license issue fee. There's often milestone payments which are payable during the clinical development of the technology. There's usually a payment at the conclusion of a phase 1 clinical trial. There's usually another payment that's due at the conclusion, or as I should say, the successful conclusion of a phase 2 clinical trial, and so on. And it's usually a fairly large payment when the licensee receives an NDA from the FDA. It's a new drug approval. The licensee also has often due diligence milestones which are required, and the failure to comply is often considered a breach of the license agreement subject to termination. In other words, the licensee has to do certain things in order to commercialize the technology, such as conduct various clinical trials all the way to a new drug approval from the FDA. An example of a non-exclusive license might be a license to a mechanical device, for instance. Let's take an example of a numerically controlled robotic drilling technology. This is often used in the manufacture of devices such as printed circuit boards and so on, where there are thousands of holes have to be driven in a panel. The drilling machines are very sophisticated, they're computerized, they're numerically controlled, and they're totally robotic. Again, they're also used for precision drilling of an irregular curved surface, such as a wing or a fuselage panel on an aircraft. Very often, this might be licensed to a specialty tool manufacturer. In a license like this, you might license the patents, plus unpatented know-how might also go along with the license. The term of a license like this might be 10 years or so. There'd be no field of use limitations, primarily because it would be difficult to enforce a field of use limitation in a non-exclusive license, because there might be multiple licensees for non-exclusive licenses. There are often, because the license is non-exclusive, it might be a modest upfront fee, let's say like $65 million, for instance, which in the licensing world, we usually consider that modest. Earned royalties might be somewhere on the order of 15% of net sales. And there'll also be hourly payments for technical assistance provided by the licensor. In other words, if the licensee requires that the licensor help them commercialize the license or provide some technical service to help the licensee manufacture this mechanical device, the licensor can charge payment on an hourly basis for that technical service. So that's an example of a non-exclusive license. We also have software licensing. That software licenses are often a little different. They're licensed to value-added resellers. If you're going to license a source code as opposed to object code, you might license only to a value-added reseller. There'll often be very large fees involved in licensing source code. Earn royalties on sales to end users, and support may be provided but negotiable. Just for those of you who might not understand the difference between source code and object code, there's an analogy that I like to draw. if you license object code, you're licensing the use of the technology. It's kind of like you're renting an apartment in an apartment building, but you don't own or you're not renting the whole apartment building. In source code, you're licensing the entire building. That's the analogy that I always like to draw. When you buy a copy of, let's say, Microsoft Office or Microsoft Word or something like that, what you're licensing is the object code. If a company wants to license the whole thing from Microsoft, then they want to license all the hidden code and everything behind Microsoft Office, they would be licensing the source code. So the source code is a lot more valuable than the object code. Under an object code license, the license is typically only to end users. There's what we call site licenses, which have a limited number of seats, which are often defined in a license agreement. There's also single user licenses, like, for instance, when you go down to any store that sells software, like such as Staples or something like that, and you want to license technology from like Microsoft Office, that would be a single user license. You can usually subscribe to upgrades, which may be provided for an extra fee or no extra fee, depending upon what you paid for the software to begin with. And maintenance and support is usually provided at least for a limited period of time. You could possibly pay for a separate maintenance agreement that could include upgrades. There's also what we call open source. Open source software is usually put on the internet for anybody to use. Excuse me. It cannot be licensed commercially because it's available for anybody. A licensor must be careful that no open source is included in the code which is licensed commercially. Under licensing fundamentals, there's what we call business terms, and that defines what is actually licensed. Are they patents? Are they copyrights, trademarks, or know-how? Know-how is often referred to as trade secrets. Excuse me. There's also various types of licenses which define the scope of rights. Manufacturing rights, sales rights, distribution rights, usage rights, and so on. Business terms often include the term of the license. How long is the license going to last? There's a territory. Are you licensing for the whole world, or are you licensing for specific nations within the world? Under the business terms, there's also consideration. Royalties, what's a royalty rate going to be? Upfront licensing fees. There's also what we call maintenance fees. I referred earlier in the example of an exclusive license to a healthcare company, to a large pharmaceutical company. There'll often be maintenance fees which are payable upon the achievement of certain milestones. And those are also called milestone payments, but sometimes maintenance fees can be payable on a periodic basis, like every year or every 6 months or something like that. Maintenance fees are often terminable once earned royalties start to kick in. So if you're developing a new drug, for instance, you can't actually sell that drug until you have a new drug approval from the FDA. So you can't actually earn royalties until you start selling the drug. And so you might have maintenance fees during that period of time. The maintenance fees will terminate as soon as royalties begin. Under licensing fundamentals, there's also what we call due diligence obligations. There's insurance obligations. There's indemnification in case there's a product liability lawsuit, for instance. The licensor has to indemnify the licensee. There's also choice of law. If you're going to license in France, for instance, and you're a U.S. company, you'd rather have a choice of law be somewhere in the United States so that if there is a litigation or some sort of a legal dispute going on, you don't have to travel to France. You have the litigation would be adjudicated in the United States. There's also terms which would define when the license could be terminated. One thing to remember in licensing, and I call it the dog-eat-dog world of intellectual property and licensing. This is a hardball game that you're playing, especially when you're dealing with a large corporation. If you're a small company and you want to license your technology to a larger corporation, don't be surprised if you find yourself sitting across a table from a group of attorneys. And they're going to do everything they can to whittle you down so that they have to get as much from you and pay as they can and pay as little as they can. It's really that simple. So bear that in mind, please. Another thing that you should bear in mind are the whole world of secrecy agreements. Before you start negotiating a license or somebody else wants to use your technology, you don't want them blabbing to the world about what your technology is all about or what the terms of a license agreement might be. So secrecy agreements are usually short agreements. They do protect your intellectual property. They establish a paper trail of what information was transferred and when. My advice is don't ever spend a lot of time negotiating in terms of a secrecy agreement. Most of them are pretty standard. The language often varies a lot, but usually they're pretty standard. There are a list of standard exceptions in a secrecy agreement as to when the confidentiality can be compromised. Like, for instance, if the information is previously known, or if the information becomes available to the public through a different way, the information is lawfully obtained from a third party, or the company that you're revealing the information to has independently developed that same information, or if a court requires a disclosure of such information. Preparation for a license agreement. Before you sit down at a negotiating table, it really helps. In fact, it's critical that you prepare properly for this license. The first thing you need to determine are what are your own objectives in wanting to do this license. What do you want to get out of it? Is it simply money, or would you prefer that your technology be commercialized? It's important for you to know what you want, because it forms a basis for your negotiating. The other thing that's important to know is what are the other what are the other side's objectives? What do they want out of the license agreement? What are they going to use the technology for? Is it going to fulfill an unmet need of theirs, for instance? Is it going to give them an advantage over their competition? Another thing to know is, and you should always do this, is do a market assessment on your technology. What's the size of the market for the technology that you have? Some technologies have a limited market of only a few $100,000 a year, whereas other technologies, such as an anti-cancer drug, might have a market, a worldwide market of several $100 million a year. And really, that affects how much your licensee might be willing to pay for this license, and so on. How does your potential partner fit into the market? We call this competitive landscape. Who are their competitors? Are they a large competitor, or are they a tiny competitor? Do they want to gain a competitive edge because they don't have one? And also, it helps to know how your technology will fit in with their unmet needs and what kind of an advantage it will give them against their competition. When you do a competitive landscape, also you'll learn how your potential licensee fits in with the rest of the industry. They might be a very obscure competitor, or they may be a leader in the field. Believe it or not, a leader in the field may not be the best licensee simply because they might have other projects they're working on, and your technology may just be one of a long list of projects that they have. Whereas a smaller licensee, this may be a major priority for them. That's something that you should determine before you sit down at the table. What kind of a deal do you want to do? Or what kind of deal does your partner want to do? How is it best structured? Is it going to be a straight technology license? Is it going to be a development partnership? Is it going to be, for instance, a simple distributor agreement? What kind of a deal is being anticipated here before you sit down at the negotiating table? Otherwise, you sit down at the table, you've got this big question mark in your mind. Well, what are we going to do? How are we going to sit down? What kind of an agreement are we going to have here? Best answer that question before you sit down. And they may have a different answer than you do, and that's perhaps the very first hour you spend negotiating. A big picture, and this goes back to some of the questions I just posed, such as, why are we going into business together? Both sides' goals should complement each other. The best possible deal is one where you can sit down together and have with the attitude that what can we do for each other? How can we complement each other's needs? As opposed to the adversarial kind of a relationship where you go in, each side goes in with the attitude of, what are you going to do for me today? There has to be a benefit for both parties. Otherwise, you don't have a basis for an agreement. There's always possible synergies. If you're going to do a research collaboration or a strategic partnership, for instance, maybe either side has technologies of their own which may complement each other and may enhance the value of both technologies. 1 + 1 = 3. That's what we call synergy. Most likely, this could be at least a basis for a long-term relationship. And sometimes these long-term relationships are very beneficial to both parties. It's good to have a consensus about the terms and the items which are going to be brought to the table. So that's what I call the big picture. The general strategy. Your best negotiations are usually not adversarial. The most adversarial license agreements I've seen are ones where somebody is actually infringing on a patent that you own and you have to take them to court or get them to negotiate a license. Those are adversarial. But if you're going to negotiate an agreement to commercialize early stage or new technology that you have, you really don't want this to be adversarial. If it is, it sets the tone for the continuation of that relationship. So try to keep it friendly. Generally, it should not be high pressure. You want to sit on the table, establish a relationship, and get along with each other. You also should know your needs versus wants when you sit down at the negotiating table. What do you really have to get out of this license versus what would you like to get out of this license? Needs versus wants. Helps to know your partner's needs versus wants. And sometimes you can figure that out just by asking a few leading questions of your partner. And perhaps you already know what their needs are versus the wants are. They may already have described those for them and why they want the license. That's very revealing. The other thing that's important is, and you can't always do this, but it's important to deal with the decision maker whenever possible. Sometimes a decision maker will send their emissaries or their representatives to the license negotiating table, and then the deal maker then has to agree to it and sign off on it, as opposed to if you have the decision maker at the table when you're negotiating, it tends to shorten the conversation, and you're dealing with the person who's going to make a decision right off the bat. So it always helps. Another thing that's important when you negotiate an agreement like this is negotiate with term sheets first. Get a meeting of the minds with respect to the terms of the agreement. what is a royalty rate that they could agree to, or at least a range in royalty rates? What kind of money are they willing to pay up front? You know, if they mention to you, oh, we'll just pay $25,000 up front when you want $250,000 up front, you obviously don't have a meeting in the minds. But if you can get a meeting in the minds, they should be outlined on what we call a term sheet. Usually it's 1 to 3 pages on a term sheet. And you usually don't put legal clauses on a term sheet. You reserve those for the actual license agreement itself. And so, but the term sheets outline the business terms of a license. Once you have a term sheet in place and both sides have initialed it, then you can really start negotiate or get into the weeds of negotiating the actual license agreement. Do your homework. What other companies are in the industry? You really need to be familiar with the industry before you sit down at the table, because if you can display your knowledge of the industry to your licensee, then that will gain some respect from your licensee. They'll know, they'll be able to see that you know what you're talking about, and that helps a lot. Where is the market for this particular technology? Is it an emerging market? Is it a growth market? Is it a mature market, or is it a declining market? Very often, growth markets can get some of the best licensing terms. Emerging markets are more risky, so they would not necessarily get the best licensing terms. A mature market means that your technology might just be another Me Too product. In growth markets, for instance, there's a lot of activity. It's a fairly new market, but it's growing. And as it's growing, the potential for sales in that area is very great. How competitive, under the market landscape, how competitive is your market? Who is who in the business? Who are the major players? Who has what technology? You know, for instance, Pfizer may have the best anti-cancer technology in the business, whereas Bristol Myers Squibb might just have another anti-cancer technology that's just not selling as well. And Bristol Myers Squibb, for instance, wants to overtake Pfizer, so they need something new. Who has what? If they're the leader in the business, they may not be as interested in your technology as a company that's not a leader in the business. Which goes back to what I said earlier, and the best target licensee may not necessarily be the biggest or the best leader. What does it cost to produce a product related to your technology? It's where the COGS is, the cost of goods sold. What are products sold for? What are selling prices? Another good question. And how much is the volume of products? What's typical? What are typical gross sales margins? Some sales margins may be 20% of the selling price. Other sales margins may be 50% of the selling price. It helps to know these things. What are typical royalties for these types of products or this type of technology? Some technologies may command, for instance, a 0.5% royalty. That's usually, you see that in commodities and things like that, where other specialty products, such as I keep hearkening back to a new drug because they usually command the best royalties. A brand new drug that cures a very common disease, that's where the market is significant. You might have as much as between a 5 and a 10% royalty, as opposed to a 0.5% royalty that you see in commodities, and so on. Another important thing is, what do I want to know about my licensee? Typically, best guess is why the company wants the license in the first place. Boy, that's probably one of the most important things there are. They may need your technology in order to compete successfully, or they may see a tremendous growth potential in your technology. It could be an extension of their current offerings. your technology, they might want to use that to eliminate some competition. It might provide them with a good cash cow, for instance, a safety net. It could also provide them with the background technology from which they can do more exploratory research and develop new improvements on your technology, which could put them in a very competitive situation. What are their values? I know that major pharmaceutical companies are accustomed to licensing technology. They look for technology from smaller companies because they think that's where good ideas and good technology come from. Whereas years ago, I used to deal with a few electronic companies, such as Motorola, for instance, and I remember that they just didn't like to pay any royalties at all. They wanted to either pay a single payment up front for the technology, or they didn't want to pay anything at all, which caused us to walk away from the table. How flexible are they? Some companies have a culture where they just are not able to account for sales figures or royalties and things like that, so they don't want to pay royalties. Some companies do not believe in new innovations. I can think of one company, for instance. Let me use an example. Morton Salt Company. They sell salt. It's a commodity. They really have little desire to innovate new technologies and so on. The structure of other deals with companies, royalties, milestones, upfronts, timelines, whether or not they're willing to pay make these types of payments, or the magnitude of these types of payments, depends largely on the culture of that particular company and what they're accustomed to doing. And that's something that you might want to bear in mind, or you might want to find out about before you sit down with a licensee. Your first communication. This is before you even sit down at the negotiating table. It helps to learn some broad issues. Some of the fundamental questions are like, what do they want in a license? Why do they want the license agreement? Who has approached who? Did you approach them? That's what we call pushing. Or did they approach you? It's called pulling. If they approach you, it puts you in a better bargaining position. You could ask them on the phone, okay, what kind of a deal are you looking for? Are you looking for a license? Would you like us to collaborate with your company in sort of a research collaboration or some sort of partnership? Do you have some technology which could be used in conjunction with ours? And so what kind of a deal structure would you want that would involve both technologies? And if they ask you, well, what kind of a royalty and upfront payment are you going to expect? If they ask you a question like that, well, don't put out too much specific information. Just deal in general terms. Well, we could deal with some small upfront payments and larger royalties, or we might want to entertain the possibility of a larger upfront payment in which you can buy down the royalty rate, and so on and so forth. One trick I always used when I sit down in the first communication with a company, or I speak on the phone with them, it helps sets the mood for a technology that might be worth only about maybe $20,000 up front. I might say with a twinkle in my eye, well, I'll guarantee not to charge you anything more than $50 million up front. Is that okay? And they either think I'm being serious and they walk away, or they realize I'm just joking with them, which is usually the case. And if they realize I'm just joking with them, then we automatically have begun the establishment of a strong relationship right off the bat. So it's helps to speak in general terms, but even to inject a little humor into it usually helps set a tone. If they want to know about general terms like royalty rates, speak in ranges. Don't be specific. If the general terms are too general, and always volunteer to prepare the first draft. He who does the drafting controls 80% of the negotiating. That's important to know, because then they have to read your draft and they have to edit your draft, but usually you get to keep most of what you wrote in the draft of the license agreement. So that helps. A few strategies to keep in mind. When you prepare for a license negotiation or any type of negotiation, determine and prioritize what the possible issues are. And you might be able to determine that during your first communication with the licensee, or sometimes you can anticipate what the issues are if you know the culture of your licensee and so on, what's important to them, what's not important to them. Another thing that's really important to you is to determine your BATNA. That's an acronym, stands for the best alternative to a negotiated agreement. And also it helps to know what the other party's BATNA is, which you can't always determine, but if you can, that's very helpful. Who else you're going to go to if you have to walk away from the table? That's basically what the BATNA is. Are you going to just walk away from the table and not have a licensee? Or do you have another company that might be interested in the license as well? Creating value is important. And when I mentioned earlier, the use of a little humor sometimes helps build trust. Sometimes if you share a little information that you feel comfortable with sharing, also helps to build trust. You might even ask a few diagnostic questions, like, why? Why do you need this license agreement? Do you have any idea what you're going to use it for? Do you have a market that you can that you're not satisfying right now, where you think our technology can help, or we can help you? That helps build trust. Negotiating issues simultaneously and not separately, that's a little surreptitious, but sometimes it helps to group issues together, because that is where you get a little give and take. If I give you this, will you give me that? That kind of a thing. That's a good negotiating technique. And it's to make multiple offers simultaneously. That's another technique. Like, we can do this, or we can do it this way. Which would you prefer? That is a technique which I love to use, simply because once you give the other side some alternatives, psychologically they tend to stick with those alternatives, and they'll give you one or the other, and usually either alternative is acceptable to you. So when you give them alternatives, you give them choices. You give them choices, then you're usually getting one thing or another of what you want. Another thing is, don't ever reveal your BATNA. You don't want to say to the other side, well, if we can't agree on a license, I'll just take it. I'll take the technology and the license to some other company. Or, if you're company A, if you can't agree, I'll just go license to company B. That's offensive. And that's likely to intimidate the other side. It will undermine the trusting relationship when you negotiate. So it's not a good idea. So don't reveal your BATNA. Open first if you're prepared. Like, put your proposal on the table. Some people say it's not a good idea to do that because you might be negotiating against yourself. Well, if you're prepared to defend your proposal, then it's okay to put your proposal on the table. If you think it's a fair proposal, it's a reasonable proposal, it's a defensible proposal, like, we're asking for X amount of royalties, and here's why, and here's the market for this technology. This is what kind of profit you're going to make from this technology. So we feel this royalty rate is fair. It makes it difficult for the other side to argue. Anchoring. Anchoring is the first price, is a starting point from which all changes will be made. If you ask for an 8% royalty, for instance, that's your anchor. The other side's not going to come back and offer you 9%. They're going to try and whittle that 8% down. So be careful when you anchor. You don't want to leave money on the table. And that goes back to opening first. So if you have a defensible position, it's okay to anchor. If the other party opens with, say, well, we'll just offer you 3% royalty. Well, you could re-anchor by saying, well, 3% royalty is kind of low. Here's what we would want to see. We'd like to see a 6% royalty, for instance. And so now you've re-anchored. And so then you're negotiating within the range. You're negotiating between 3% and 6%. Watch the magnitude of concessions. If you make a concession to the other side, what's that concession worth to the other side versus what is it worth to you? If an upfront fee, or if say a royalty rate, if you make a concession on a royalty rate, say you agree to go down from 6% to 4% as an example, what is that worth to the other side? How does that affect the other side's profits versus how does it affect your profits? You just reduced the possible royalty you can get by 33% for going from 6% to 4%. Well, 6% to 4% to the other side might only be worth 8% on their profit margin. So be careful about what kind of the value of a concession that you make may be worth a lot more to you than be worth to the other side. And the same argument goes for recognizing the even split ploy. Like, the other side might say to you, well, why don't we just split the difference? Well, splitting a difference may, again, be worth a lot more to you than it does to them. So that's something that you might want to take your pen or pencil and write down, do a little calculation on a piece of paper and see if that's worth it. If the other side wants to make an even split, or if they ask you for certain concessions and so on. Key psychological principles are important here. Capitalize on the power of reciprocity. If I do this for you, what are you going to do for me? That's the power of reciprocity. You're asking a question, you're sort of asking something, you're sort of offering something, but you're asking for something else in return. The other side feels obligated to reciprocate. That's a psychological technique in negotiating. Seek a verbal commitment. If the other side says, we're willing to pay you 4% royalty, well, they just made a verbal commitment, and you don't necessarily want to let them forget that. Fairness is relative. If you take a position and you think it's fair, they may not think it's fair. So one thing that you can do is, if they don't think it's fair, ask them to explain why they think it's not fair. And then again, that kind of obligates them to explain something to you, and obligates them to make a verbal commitment, for instance. And they may tell you what they think is fair, and that's where you get some back and forth going. And you can have a candid conversation that way as well. Draft a term sheet. As I mentioned earlier, term sheets are important. They outline the general structure of a deal. They define a meeting of the minds. Once you have a term sheet drafted, you have a meeting of the minds down on paper. So if somebody comes back and asks for something that's outside the term sheet, then all of a sudden you don't have a meeting of the minds anymore. So if you have a term sheet in which a meeting of the minds is down on paper and it's written, it's a lot easier to get that license agreement done. Usually the term sheet defines the financial terms only. Complicated legal language will only cause confusion of the issues and delay. So save the legalese for the license agreement. If you're the one who drafts the term sheet, then you're setting the agenda and you're controlling the official document. Remember, I said earlier that he who does the drafting controls 80% of the negotiation. That's something to bear in mind. You want to set the agenda and you want to control the official document. Anchoring. Again, I mentioned anchoring before. The first price is at the starting point from which all changes will be made at that point. Your interest will be down on paper because you're drafting a term sheet. You're certainly putting your interest on paper. Once it's written, once it's down on a term sheet, it's much, much more difficult to erase. And both sides know that. You negotiate using the term sheet. The biggest, most important details are generally resolved at the term sheet. The royalty rates. Typically, I use that as an example, but that's usually the most important part of a license agreement is what the royalties are going to be. And often, because you're usually negotiating from a distance, it's often generally done via email, which depends on the culture. Sometimes you can work on it by email. You can go back and forth by email. You might reach an impasse on certain issues, but they could be resolved. And sometimes after you get to a certain point, you can't make too much progress by email. You might want to think about, well, okay, why don't we meet face to face and literally sit across a table from each other and work this out. And that generally helps, because when you put faces behind the names and you're sitting across a table and you're having lunch together, things like that, you'd be surprised as to what can get resolved that way that could not get resolved by email. You keep control of the official document. When documents go back and forth, version control is often important too. So maintain control of the official document. It's always in good form to send a red line in addition to a clean version. So a clean version shows the version of the terms of that particular version of the term sheet, but when somebody redlines it, the red line displays what changes have been made. When you do that, you're helping the trusting relationship, because you're not trying to hide any changes that you want to make. Sometimes in a long document, especially in the license agreement itself, if you don't redline it, the other side has to go through it with a fine-tooth comb, and if they discover that a change has been made without being redlined, it tends to make them believe that you're trying to hide something. That's not a good idea. Once a consensus is reached, get both parties to sign or at least initial the term sheet. And again, volunteer. In addition to the term sheet, volunteer to draft the license itself. And working with the whole agreement. Understand objections and propose changes. If somebody makes an objection in the license agreement, and very often it might, at this stage of the game, might actually be a corporate attorney that made an objection to some part of the agreement, you need to understand why they made that objection. And in any negotiation like this, it helps to ask questions. If they've made an objection and you don't understand it, just simply ask them why. Why is this objection being made? Could you please explain it to me? Sometimes when they explain it to you, you may see the light and you may say, oh, well, that's okay. Or you may say, oh, I don't know, it doesn't really fit with our objectives as well. And then you have to negotiate that part. At this point in time, it helps to involve a legal department or a superior colleague on strange issues. The other side may have an issue that you just don't understand, where the lawyer may understand it better, or a superior colleague may understand it better because they may have more experience, and so on and so forth. If you're a small company or you're a startup company, this is where a consultant that understands these kinds of issues can actually help and explain it to you. The legalese can be a large hurdle to completion. Sometimes the smallest issues are hardest to agree upon. Indemnification, as an example. Insurance requirements, as an example. You may have in a license agreement where you're requiring the licensee to provide insurance and make you a co-insured on their insurance policy. and you may require them to indemnify you in case they get sued for, say, product liability or something like that. It sounds like a small issue because the risk involved may be remote, so it may be a small issue to you, but it may not be a small issue to them, or vice versa. If they don't indemnify you, you could be named as a defendant in a lawsuit because you own the patent, and they need to indemnify you. So you may not think that's a big issue, but it can be a huge issue. So sometimes these are what may be legal language can turn out to be a large hurdle. Revising the terms from a signed term sheet should always be a last resort. That term sheet is something that should be as close to being written in stone as possible. If you end up in a major impasse because some decision maker or some person from the other side's legal department objected to something, then it might result in an impasse, and you might have to go back and rethink a term sheet. But remember what I said: term sheet should just be on the business terms of a license agreement, such as the numbers. I believe that the lawyers should never quibble with the numbers. They should stick with the legalese in the license and not try to change the numbers. Although I've seen that happen, and it's not a good idea. But be reluctant to change the terms in a term sheet. Responding to red lines on the whole agreement. And again, this goes back to issues which you may not understand. So get to know the other party's issues. How important are their objections? Are they deal breakers? Are they strategic objections? Are they legitimate objections? Or is it just some whim that a lawyer had because of the legalese doesn't, or the wording doesn't fit with the way they might have worded it, but the meaning doesn't change an awful lot. Sometimes you run into that as well. How do the red lines affect your issues? What are your priorities? If they redline an agreement, if they make changes in agreement, what changes can you live with? Think about that. Are they needs or are they wants? What do you not care about? They may make changes. A lawyer may make changes in the verbiage in the license agreement that you may not even care about. You may look at the verbiage that they change that may actually fit with what you want, and you may look at that verbiage and say, gee, they worded it better than I could have. So when you see the red lines, look at them seriously. How important are they? What can you live with? Are there areas where you might be able to compromise, and so on? That's important. Completing the deal. If you have multiple issues, it's good to trade issues. That goes back to, well, if I do this for you, what are you going to do for me? So that's trading issues. Or how can we compromise this? Well, you might be down to make 2 or 3 issues in the agreement, and that might be holding up completing a deal, and you might want to find a middle ground. Can we find a compromise to finalize this thing? Again, completing a deal should be inquiring and not adversarial. Always be a principled negotiator. Don't negotiate hard. Don't be too soft. Just be honest, be candid, earn the other side's respect. Be a person with whom they want to sit down and shake hands, and after the agreement is signed, they want to go to dinner with you and have a glass of wine or whatever you want. If you end up with a large issue that you haven't resolved and you need to get this one issue resolved, it's always helpful to pose the question, look at what is it going to take to finalize this deal? What is it going to take? And they may want to ask you the same question. Remember, what you're negotiating is a long-term commitment. You're not buying a used car here. You're negotiating a deal that could be that could end up structuring a partnership or a business relationship that could last for many years. And you want to bear that in mind. True technology transfer is not simply negotiating and executing a suitable license to a patentable invention. However, in no way constitutes a true transfer of the technology. Once the license agreement is finalized, the licensee or the partner will often want to establish a strong relationship with the subject matter experts so that the licensee may learn more detail about how to practice the invention. Despite the detail contained in a patent or patent application, there is invariably certain know-how or trade secrets which cannot be adequately described on paper. And collaborating or commiserating with each other to help get this technology commercialized is what represents true technology transfer. And that concludes the webinar for today, and I thank you for your interest.